Hello, Stephen Avery Project people. The filing has just been uploaded. You can get it online. Ooh, and I know I'm this spooky color right now. I don't know if I should close more of my blinds. So I'm not, I'm still spooky. So, okay. So this filing is 150 pages. And so first is a table of contents that we're not going to read through. And I haven't looked at this. This literally just came up. And while I'm reading this, I will not be answering any of your questions or looking at any of the stuff you post in here. Because I'm just going to concentrate on this right now. And also, just so you know, my laptop has been sketchy as of late and randomly just shutting off on me. So if I go bye-bye, it's because my laptop is stupid. Scrolling through all this table of contents stuff. Still scrolling. I'm now on page 13 of still scrolling through all this table of contents stuff that we don't need to read. On page 16, it says issues presented. Did the circuit court abuse its discretion in denying Mr. Avery's motion to vacate its October 3, 2017 order and allow additional scientific testing? The circuit court answered no. Did the circuit court abuse its discretion in summarily dismissing Mr. Avery's second motion pursuant to Wisconsin statutes 974.06 without addressing the 5 Brady claims raised and in subsequently denying Mr. Avery's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution? The circuit court did not address the 5 Brady claims. The circuit court answered no to the 6th Brady claim. Did the circuit court err as a matter of law in failing to address Mr. Avery's claim of ineffective assistance of trial counsel? The circuit court answered no. Did the circuit court err as a matter of law in ruling that it was not authorized by statute to resolve claims of ineffective assistance of counsel, of prior counsel, and that Mr. Avery would have to pursue that claim with the Court of Appeals pursuant to State versus Knight? The circuit court answered no. Did the circuit court abuse its discretion in dismissing Mr. Avery's second motion pursuant to Wisconsin statutes 974.06 without requiring the state to respond or conduct an evidentiary hearing? The circuit court answered no. Did the circuit court err as a matter of law in applying the wrong standard to the newly discovered evidence? The circuit court answered no. Did the circuit court abuse its discretion in ruling that the second motion of Mr. Avery pursuant to Wisconsin statute 974.06 failed to show a sufficient reason as to why these issues could not have been raised in prior motions and is therefore barred by State versus blah, blah, blah? The circuit court answered no. Did the circuit court abuse its discretion by denying Mr. Avery's motion to reconsider and his 3 supplements to said motion, which included new evidence developed after his original filings on June 7, 2017? The circuit court answered no. Did the circuit court abuse its discretion in ignoring the subsequent briefs submitted by the parties incident to the motion to supplement? The circuit court answered no. Did the circuit court abuse its discretion by denying Mr. Avery's supplemental 974.06 motion for new trial pertaining to the discovery of human bones in the Manitowoc County gravel pit? Sorry, let me turn that off, at least on my phone. In the Manitowoc County gravel pit southwest of the supposed crime scene? The circuit court answered no. Statement on oral argument and publication. Pursuant to Wisconsin statute 80 809.22, appellant requests oral argument to facilitate review of the complex legal issues raised herein, some of which are believed to be of first impression. Pursuant to Wisconsin Statute Rule 809.23, a publication is warranted because the case is of interest to the public and raises issues believed to be of the first impression. Now we're on page 20 of 150. I need to move this periodically so it doesn't shut down on me, I guess. And it's titled Statement of the Case and Procedural History. The state's case. In the 4 months before her murder, 25-year-old Teresa Hallback had been to the Avery salvage yard to take photographs of vehicles 5 times. June 20, 2005, August 22, 2005, August 29, 2005, September 19, 2005, and October 10, 2005. Ms. Hallback worked for Auto Trader magazine and had her own photography business. Auto Trader is a magazine that contains advertisements and photos of automobiles for sale. Stephen Avery had arranged hustle shots with Ms. Hallback previously by calling her cell phone directly, as he did on October 10, 2005. Because hustle shots were not prearranged, the Auto Trader office did not know about such shots until after they occurred when the billing took place. A photographer earned more from a hustle shot than a shot prearranged through Auto Trader. Ms. Hallback did many such hustle shots. And then there's the footnote on the bottom of this page that says, citations to the record on appeal appear with the document number before the colon, blah, blah, blah. Okay, we don't need to read that. A, the state's timeline for October 31, 2005 and witnesses. 8:12 a.m. According to the state, Mr. Avery called Auto Trader and spoke with Dawn Pliska, the Auto Trader receptionist, in an attempt to allure Ms. Hallback to the Avery salvage yard by setting up a photo shoot appointment for his sister Barb Dassey's Plymouth van. Mr. Avery called from his cell phone. Ms. Pliska testified that the caller left the telephone number, the landline number for the Dassey Yanda residence, and the Dassey Yanda, hold on. I have to look at this. Nothing coming up. Where was I? Okay, so in the Dassey Yanda residence, 9:46 a.m. Ms. Pliska testified about an incoming call from Auto Trader to Ms. Hallback, allegedly leaving the Dassey Yanda phone number and their address. 11:43 a.m. Ms. Hallback called the Dassey Yanda number and left a message on their answering machine, which stated, quote, I don't have your address or anything, so I can't stop by without getting a call back from you. 1:10 p.m. Ms. Hallback arrived at Stephen Schmitz's residence. The state presented an incorrect timeline. Sorry. Trying to multitask. Sorry, I know that's annoying. The state presented an incorrect timeline to the jury. Based upon Mr. Schmitz's erroneous recollection that he received a call from Ms. Hallback at 1:10 p.m. That should be the last one, hopefully. Ms. Hallback's phone records show that she called Mr. Schmitz at 12:51 p.m. Therefore, contrary to the state's timeline, Ms. Hallback arrived 20 minutes earlier to the Schmitz residence than the state represented to the jury. 2:12 p.m. Ms. Hallback called the Zipper residence and left a voicemail on the Zipper answering machine stating that she could not find their residence. This voicemail is missing and was never turned over to trial defense counsel. 2:24 p.m. The state claimed that as part of Mr. Avery's effort to lure Ms. Hallback to his property, Mr. Avery used, quote, the star 67 or blocked feature where the recipient of that call can't tell who is calling, unquote. Ms. Hallback did not answer this telephone call, and Mr. Avery did not leave a message. 2:27 p.m. Ms. Hallback spoke to Ms. Pliska and allegedly informed her that she was on her way to the Avery property. The state provided no explanation of how the unanswered 2:24 p.m. star 67 call would have lured Ms. Hallback to the Avery property. 3 minutes later, Ms. Hallback told Ms. Pliska that she was on the way to the Avery property at 2:27 p.m. The state never explained how Ms. Hallback learned of the Dassey-Yanda address. The telephone records of Auto Trader, Ms. Hallback, and Mr. Avery do not show contact between Ms. Hallback and Mr. Avery from 11:43 a.m. to 2:27 p.m. Ms. Hallback's text and computer messages were never retrieved by the state. What? Okay. 2:35 p.m. Mr. Avery placed a second star 67 call at 2:35 p.m., but the call was never connected. 2:32 to 2:45 p.m. The state's primary witness was Bobby Dassey, who testified that he was asleep and woke up around 2:30 p.m. and looked out of the kitchen window of the Dassey-Yanda residence. Bobby testified that he saw Ms. Hallback's RAV4 pull up, Ms. Hallback exit the vehicle, and start taking pictures of the Dassey-Yanda van. When Ms. Hallback finished photographing the van, Bobby saw her, quote, walking up towards Uncle Steve's trailer, unquote. Bobby then took a shower, and when he left the property at about 2:45 p.m. to go bow hunting, he saw that Ms. Hallback's RAV4 was still on the property, but he did not see her. Based upon Bobby's testimony, the state claimed that Mr. Avery was the last person to see Ms. Hallback alive. 2:41 to 2:43 p.m. Ms. Hallback's records indicate that a call was actively forwarded at 2:41 p.m. using the call forward no answer feature. After the 2:41 p.m. call on October 31, there are no other CFNA messages left. Rather, the subsequent calls are voicemails without CFNA. The 2:41 p.m. call to Ms. Hallback's phone pinged off of the Whitelaw Tower, which was 7.8 miles away from the Avery property. 3 p.m. Scott Toddick, Barb's boyfriend, testified that at about 3 p.m. he went bow hunting in Kewanee, and as he drove on Highway 147 going west, he saw Bobby driving east. 3:46 to 3:47 p.m. Bobby's brother, Blaine Dassey, testified that at approximately 3:46 p.m. or 3:47 p.m., after he got off the school bus and was walking home, he saw Mr. Avery place a plastic bag in his burn barrel, and the barrel had white smoke and flames coming out of it. The state prosecutor, Kenneth Kratz, claimed that by 4:35 p.m., Mr. Avery had burned Ms. Hallback's electronic devices in his burn barrel. 4:35 p.m. According to the state, Mr. Avery placed an alibi call to Ms. Hallback's phone from his landline. 4:45 p.m. dusk. Mr. Robert Fabian, a friend of Earl Avery's, testified that he saw smoke and smelled plastic being burned in Mr. Avery's burn barrel around dusk. 7:30 to 7:45 p.m. Mr. Toddick testified that he saw a large fire in Mr. Avery's burn pit with flames reaching above the roof of the garage, and he saw Mr. Avery standing by the fire. The state claimed that Ms. Hallback was already murdered by this point, and Mr. Avery was in the process of destroying and mutilating and burning her body in his burn pit. 11 p.m. When Blaine got home from trick-or-treating, he testified that he saw, quote, Stephen Avery sitting there watching the fire, unquote, and that the flames were about 4 or 5 feet. And then the little, whatever you call it, footnote on the bottom of this page says, the state failed to identify the following calls on October 31, 2005. 8:17 a.m. from Auto Trader to Ms. Hallback. 8:39 a.m. from Mr. Avery to Bobby. 10:44 a.m. from Denise Heidel to Ms. Hallback. 10:52 a.m. from Auto Trader to Ms. Hallback. 11:04 a.m. from Mr. Avery to Auto Trader. 11:35 a.m. from Ms. Hallback to Ms. Heidel. And 12:44 p.m. from Stephen Speckman to Ms. Hallback. Next section, the state's forensic evidence. Sorry, I have to keep doing this to try and make sure my stuff doesn't shut off on me. The state's case against Mr. Avery was based almost exclusively on circumstantial forensic evidence. The critical facts related to the state's forensic evidence are as follows. November 5, 2005. Let me put this back up here so I can try and see when I'm getting those messages. Ms. Hallback's RAV4 was discovered on the southeast corner of the Avery property by 2 civilian searchers, Pamela Sturm and her daughter Nicole Sturm, within 30 to 35 minutes of their arrival. According to the state, the speed with which Pam located Ms. Hallback's RAV4 on the Avery salvage yard was attributable to, quote, the hand of God, unquote. Ms. Hallback's RAV4 was locked and partially obscured by branches, plywood, and an old vehicle hood. According to the state, the RAV4's battery had been disconnected to prevent the alarm from being activated. The state argued that it was readily apparent that Mr. Avery intended to crush Ms. Hallback's RAV4 simply because the RAV4 was found in the vicinity of the car crusher. Also, the state contended that the RAV4 could not have been driven onto the Avery property from the Rat Ant Pit because of the 15 to 20 foot high berm immediately to the south of the RAV4. And the footnote on the bottom of this says, the state presented the following experts at trial. Oh, we don't need to read that. Okay, next page. We're on page 26 of 150. So we got a long ride. Which would have prevented entry from the Rat Ant Pit onto the Avery property. November 6, 2005, Deputy David Siders found a tire rim in Mr. Avery's burn barrel. Underneath the tire rim, Ms. Hallback's electronic devices were discovered, including her Motorola V3 Razr cell phone, the circuit board for her Palm Zyre 31 Palm Pilot, and components of her Canon PowerShot A310 digital camera. Inexplicably, there were unburned cans and unscorched foliage in the burn barrel. Curiouser and curiouser. November 7, 2005, the Wisconsin State Crime Lab discovered 5 small blood drops in Ms. Hallback's vehicle. A DNA profile of Mr. Avery was obtained from these drops. November 8, 2005, human bones, a tooth root fragment, and rivets from a pair of jeans were found in the burn pit behind Mr. Avery's garage, and a RAV4 key was found in Mr. Avery's trailer. Mr. Avery's DNA profile was recovered from the RAV4 key. The RAV4 license plates were discovered in another vehicle at the Avery salvage yard during a search by a volunteer. The male DNA on the plates was insufficient to develop a full DNA profile. November 9, 2005, Mr. Avery is arrested and charged with possession of a firearm by a felon. November 15, 2005, Mr. Avery is arrested and charged with first-degree intentional homicide for the Hallback murder. March 1 to 2, 2006. Based on Brendan Dassey's alleged confessions, law enforcement conducted a search of Mr. Avery's garage and discovered fragments of 2 .22 caliber bullets that had somehow gone undetected during 6 previous searches. Prosecutor Kratz held 2 press conferences where he disclosed in great detail Brendan's alleged confession. I added alleged, sorry. Shouldn't do that. I should just read this as it is and not insert my crap into it. March 8, 2006. The state filed an amended information adding the charges of sexual assault, kidnapping, and false imprisonment counts. April 3, 2006. The hood latch of the RAV4 was swabbed. May 8, 2006. Ms. Culhane confirmed that item FL had Ms. Hallback's DNA on it, and the profile developed from the RAV4 hood latch matched Mr. Avery's DNA. June 15, 2006. The state attempted to interject 9 items of, quote, other acts, unquote, evidence into its prosecution to corroborate the amended information filed on March 8, 2006. The 9 acts consisted of 2 alleged acts of physical violence against women and 1 against a cat, 1 act of reckless endangerment, 1 act of a convicted felon in possession of a firearm, and 3 alleged acts of improper sexual behavior, and 1 act of a phone conversation of an alleged sexual nature. September 22, 2006. The trial court ruled against the state's 9 other acts evidence, holding that it failed to find any meaningful relationship between the other acts evidence and the charged offenses. In the trial court's opinion, the other acts evidence had virtually, quote, zero probative value, unquote, which would be highly prejudicial and was clearly inadmissible. February 2, 2007. The state filed a second amended information dropping the charges for sexual assault and kidnapping. At the beginning of the trial, the state convinced the court to instruct the jury about a party to a crime theory of accomplice liability as to the homicide, mutilation of a corpse, and false imprisonment charges then to be tried. Mr. Avery's blood in the RAV4 was not planted. Approximately 1 to 2 milliliters of Mr. Avery's blood, allegedly from an actively bleeding finger, was discovered in the RAV4 in 5 places, i.e. on the driver's and passenger seats, rear passenger door jamb, CD case, and by the ignition. Blood flakes were found on top of the driver's side carpet. There was no corresponding stain under the blood flakes. The state claimed that no one in law enforcement had access to Mr. Avery's blood prior to November 5, 2005 to plant it. The blood from Mr. Avery's bathroom was collected after the RAV4 was removed from the Avery property. Also, the state argued that trial defense counsel had failed to demonstrate exactly how the police could have planted Mr. Avery's blood in the RAV4 because of, quote, the sheer volume, unquote, and, quote, sheer number of places, unquote, where the blood was discovered. Prosecutor Kratz emphasized that Mr. Avery's DNA profile from his blood in Ms. Hallback's vehicle came from the cut on the middle finger of his right hand, which occurred during his struggle with Ms. Hallback. The state's blood splatter expert, Mr. Stalkey, agreed in his testimony that the ignition stain was consistent with somebody who could be actively bleeding on their right hand. In his closing, Prosecutor Kratz stated that the stain was, quote, absolutely consistent with somebody with a cut to the outside of the right hand and turning the ignition. So this, unquote. The state, through its expert, Dr. LeBeau, attempted to rule out the 1996 blood vial as the source of Mr. Avery's blood in the RAV4. The blood in the 1996 tube was preserved by using EDTA. Dr. LeBeau tested 3 of the 6 swabs from the RAV4 and claimed there was no EDTA in them. Ms. Hallback's blood in the RAV4. Mr. Stalkey, the state's blood spatter expert, claimed that after Ms. Hallback had been shot, she was thrown into the rear cargo of the RAV4, causing impact spatter on the inside of the rear cargo door. According to Mr. Stalkey, Ms. Hallback left a hair imprint from her bloodied head on the side panel of the interior of the rear cargo area. The bloody, quote, the bloody hair component, however, it is consistent with a bloody object such as a body being comploded, phonetic, into the rear end of this vehicle, unquote. There was no mixture of Mr. Avery and Ms. Hallback's blood, even though Mr. Avery allegedly tossed Ms. Hallback in the RAV4 as he was, quote, actively bleeding, unquote, from his right middle finger. Despite the blood in the interior of the RAV4 being linked to Mr. Avery, there were no fingerprints of Mr. Avery on the interior or exterior of the RAV4, even though the state's fingerprint expert, Mr. Riddle, Mr. Riddle, that's not a good name, claimed that someone with, quote, sweaty hands, unquote, was more likely to leave prints than someone with dry hands. Prosecutor Kratz contended that Mr. Avery touched the hood latch with sweaty hands that left his DNA profile. Mr. Riddle testified that he discovered 8 latent prints on the RAV4, quote, that were suitable for comparison, unquote. One of the 8 latents contained a palm print. The latent prints were located where the key for the cargo gate is inserted, along the pillar that goes above the taillight assembly, on the other side of the wheel cover, inside a rear passenger window, and on the hood. Mr. Avery was not matched to any of the 8 latent prints. The state never claimed that Mr. Avery was wearing gloves. Mr. Riddle was never asked to examine the shell casings found in Mr. Avery's garage for fingerprints. The casings were never linked to item FL. A blood stain from a male on the rear cargo door of the RAV4 did not match Mr. Avery either. Now we're on page 31 of 150. No blood of Ms. Hallback in Mr. Avery's trailer, garage, or on the 22 LR Marlin Glenfield. There was no blood of Ms. Hallback in Mr. Avery's trailer, garage, or on the 22 LR Marlin Glenfield in his bedroom that was allegedly used to shoot Ms. Hallback in the head. Mr. Avery's DNA on the RAV4 key. Between November 5 through 9, 2005, there were 7 searches of Mr. Avery's trailer. On the 6th entry on November 8, Ms. Hallback's Toyota key was observed for the first time next to Mr. Avery's bookcase in his bedroom. The state contended that Mr. Avery kept the key so that he could move the RAV4 to crush it. During the November 8 search of Mr. Avery's bedroom, Manitowoc County Sheriff's Department Sergeant Andrew Colborn conducted an hour-long search of Mr. Avery's small bookcase. Sergeant Colborn testified that he tipped and twisted the bookcase, pulling it away from the wall. Sergeant Colborn testified that he forcefully pushed the photo album into the bookcase, causing the Toyota key to fall out the back of the shelf. Sergeant Colborn never explained how the key moved from behind the shelf to a spot on the northwest side of the bookcase by Mr. Avery's slippers. Because, yeah, it would just hit the wall and drop down. It wouldn't just now go around a corner. Anyway, during Sergeant Colburn's interaction with the bookcase, MCSD Lieutenant James Lenk left the bedroom. When Lieutenant Lenk returned, he noticed a Toyota key had suddenly appeared by the northwest side of the bookcase on the carpet. Neither side subpoenaed the bookcase for trial. The state admitted that even if the key was planted, that was lovely too that they said that, even if the key was planted, as trial defense counsel claimed, the jury should, quote, set the key aside, unquote, because there was, quote, enough other evidence of Mr. Avery's guilt, unquote, and, quote, that key in the big picture in the big scheme of things here means very little, unquote. So these aren't the droids you're looking for. Don't look at this key. Look at this other stuff we did over here. The state relied upon Ms. Culhane to explain the absence of Ms. Hallback's DNA on her own key by explaining that the last person to handle the key was the most likely source of the DNA. Ms. Culhane testified that there was no mixture of Ms. Hallback and Mr. Avery's DNA on the key because, quote, if you have someone who's a good shedder and sheds a lot of DNA, when they touch something, a lot of studies show that is going to be, the last person is going to be the DNA you pick up, unquote. Ms. Hallback's body burned in Mr. Avery's burn pit. The state relied upon the testimony of forensic anthropologist Dr. Eisenberg to claim that Ms. Hallback was burned in Mr. Avery's burn pit. Dr. Eisenberg testified that the primary burning episode was in the burn pit behind Mr. Avery's garage and that, quote, at least a fragment or more of almost every bone below the neck was recovered at the burn pit or in the burn pit, unquote. Dr. Eisenberg stated on cross-examination that, quote, there is evidence from the Avery property that there was transport of human bone, and I believe that transport occurred from the original burn pit and adjacent areas to barrel number 2, unquote, which was the Dassey Yonda burn barrel. Dr. Eisenberg identified the bones designated by Calumet County evidence tag number 8675 as being located southwest from the Avery property, which is called the Manitowoc County Gravel Pit. Dr. Eisenberg testified that her second report was a spreadsheet of tag numbers and the evidence collected under each tag number. Dr. Eisenberg admitted that one bone fragment, 8675, from the Manitowoc County Gravel Pit appeared to be a human pelvic bone with, quote, a long linear cut on either side of those two bones that were still in proximity, unquote. Dr. Eisenberg, in describing the suspected human pelvic bone, stated that, quote, it was clearly a joint articulation at the right side of the pelvis where the pelvis meets the lower part of the spine, unquote. In the closing, Prosecutor Kratz stated that he would take, quote, 20 seconds, unquote, to talk about the, quote, possible human, unquote, pelvic bone in the Manitowoc County gravel pit. He said that these bones were, quote, possibly human, unquote, so, quote, it means that we don't know what it is, unquote, and, quote, Dr. Eisenberg didn't know what they were, unquote, and, quote, Dr. Fairgrieve didn't know what they were, unquote. Dr. Scott Fairgrieve was trial defense counsel's forensic anthropology expert. Some larger human bones were found in the Dassey Yonda burn barrel, evidence tag 7964. Sorry, I don't sing that one. Dr. Eisenberg described a human scapula, portions of a spinal column, metacarpals, and a fragment of long bones in the Dassey Yonda burn barrel. The bones found in the Dassey Yonda burn barrel also exhibited evidence of cut marks. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey Yonda burn barrel, she got a, quote, waft of flammable liquid or fluid, unquote, but did not smell burned rubber from tires. Prosecutor Kratz admitted the bones were moved, but claimed, quote, the big bones, unquote, were moved by Mr. Avery from his burn pit to the Dassey Yonda burn barrel, quote, a couple 100 feet away, unquote. State's Attorney Thomas Sturdivant, however you say his name, testified that the burn pit bones were, quote, intertwined or mixed in with the steel, or unquote, with the steel belt from the tires. Prosecutor Kratz stated in his closing, quote, the bones being intertwined and mixed in is the state's or one of the state's, strongest argument for this being the primary burn site, unquote. The state claimed Wisconsin Department of Justice Division of Criminal Investigation agent Rodney Pevito ruled out the smelter and the wood burner as other possible burn sites on the Avery property. The state called DCI agent Kevin Heimerl to testify to the investigators I just got new glasses last week and I've never had glasses and I'm still trying to adjust to these and things are still blurry. That the investigators found 5 out of the standard 6 gene rivets marked, quote, Daisy Fuentes, unquote, in Mr. Avery's burn pit. The state referenced Katie Hallback's testimony. Sorry, I just got an email from the clerk. Okay. look at that later. Had the state referenced Katie Hallback's testimony that Ms. Hallback had Daisy Fuentes brand jeans that were missing after her disappearance. Cause of death, 2 gunshots to head. And we are now on page 35 of 150 for those who want to read along. The state claimed that Mr. Avery backed Ms. Hallback's RAV4 into his garage, closed the garage door, placed Ms. Hallback in the rear cargo area. How would you even do that? I'm sorry, but the garage isn't big. If you have the car pulled in there and the door closed, how do you then put somebody in the back of it? There's not room. You would have to put somebody in the back of it first. And then, okay, sorry. Because this reading of this, I'm supposed to just be reading this and not inserting my crap into it. Then removed her from the RAV4, laid her on the garage floor, and shot her in the left side and back of her head. Dr. Eisenberg testified that the defect in the parietal bone above the left ear showed the characteristic sign of an entrance bullet wound, and a second defect in the occipital region showed Ms. Hallback was also shot in the back of the head with a .22 caliber gun. Additionally, the state relied upon Mr. Olson, a trace metal expert, who testified that x-rays of the skull defects in the parietal region showed particles of lead. On November 6, 2005, 11 spent shell casings were found in Mr. Avery's garage, but were never forensically linked to items FL or FK or any items of evidence in the case. The state claimed that Mr. Avery cleaned the garage, but his DNA was detected on the garage floor. Ms. Hallback's DNA on bullet, FL. There were 2 damaged bullets, FL and FK, eventually found on Mr. Avery's garage floor on March 1 and March 2, 2006. Ms. Culhane, the state's DNA analyst, performed DNA testing on both bullets, and DNA was only found on FL. After visually examining FL and observing no signs of blood, Ms. Culhane washed the bullet in a buffer solution and developed a DNA profile matching Ms. Hallback. Ms. Culhane was not able to determine the source of the DNA and testified that she could only determine that the DNA came from nucleated cells. Red blood cells do not have nuclei, so the DNA did not come from red blood cells. The state explained that Ms. Culhane's contamination of the control sample for FL with her own DNA during the testing process did not diminish the results of Ms. Culhane's DNA comparison and subsequent identification of Ms. Hallback's DNA. The state ballistics expert, Mr. Newhouse, opined that the bullet containing Ms. Hallback's DNA was fired from the .22 Marlin Glenfield rifle mounted above Mr. Avery's bed and didn't belong to him. It was Raleigh Johnson's gun, but that's not in there. But let's continue. Mr. Newhouse's worksheet did not indicate he performed a trace examination of FL. The state's forensic pathologist, Dr. Jensen, testified that Ms. Hallback's cause of death was the result of 1 or 2 gunshot wounds to her head. Specifically, Dr. Jensen testified that Ms. Hallback's DNA got on FL when it traveled through her brain, causing her death. Dr. Eisenberg testified that there was no evidence of other gunshot wounds to the bones from other parts of Ms. Hallback's body. The state, in relying upon Dr. Jensen and Dr. Eisenberg's opinions, told the jury in its closing that Ms. Hallback was killed by gunshots to her head. Now we are on page 37 of 150. Mr. Avery's DNA on hood latch. The state claimed that Mr. Avery wanted to deactivate the RAV4 alarm, so he disconnected the battery cables after he opened the hood, touching the hood latch and leaving his DNA. Prosecutor Kratz told the jury that this DNA came from Mr. Avery's sweat. There was no witness description of Mr. Avery sweating on October 31, 2005. Ms. Culhane never mentioned sweat in her hood latch testimony. Leg irons and handcuffs were seized from Mr. Avery's bedroom. Ms. Culhane confirmed that there was no DNA of Ms. Halbach on the leg irons or the handcuffs, but there was a mixture that included Mr. Avery's DNA. Ms. Culhane agreed that this meant these items were not wiped down with bleach. Mr. Avery's mattress tested negative for blood, as did his knives. No hair from Ms. Halbach was found in Mr. Avery's residence, including in his vacuum cleaner. On March 12, 2007, the state dismissed the false imprisonment charge. Only one person committed the crime. Prosecutor Kratz, in his rebuttal, told the jury, quote, "It's not a difficult decision that you have to make because everything in this case pointed towards one person, towards one defendant," unquote. The defense case. Mr. Avery was represented by retained attorneys Dean Strang and Jerome Buting. Mr. Avery paid trial defense counsel $220,000 for his defense. In contrast with the state's 14 expert witnesses, trial defense counsel presented 7 witnesses in total, only 2 of whom were qualified as experts. Defense forensic evidence, Mr. Avery's blood in the RAV4. Trial defense counsel did not have a blood spatter expert. Trial defense counsel only offered one source for the allegedly planted blood of Mr. Avery, the 1996 blood vial, which was located in an unsecured area of the courthouse. And then the footnote at the bottom of this page says, in the Dassey opinion, the court references the state's theory that Brendan participated in raping and murdering Miss Halbach with Mr. Avery, which contradicts the state's theory in Mr. Avery's trial that he was the only perpetrator. Dassey versus Dittman, blah, blah, blah. In Brendan's trial, prosecutor Kratz claimed that Ms. Halbach was killed by Mr. Avery, stabbing her in the stomach, Brendan slitting her throat, and Mr. Avery manually strangling her. Prosecutor Kratz claimed Ms. Halbach was killed in Mr. Avery's trailer, not shot in Mr. Avery's garage. Okay, now we go on to page 39 of 150. Obviously, this theory excluded anyone but law enforcement from planting Mr. Avery's blood. Trial defense counsel did not do their own independent testing of the 1996 blood tube. Rather, they relied upon the testimony of Janine Arvizu to try to refute Dr. LeBeau. Ms. Arvizu held a bachelor's degree in biochemistry and worked as a laboratory quality auditor. Ms. Arvizu testified that Dr. LeBeau's experiment did not account for the absence of a limit of detection. His protocol was rushed and no one had attempted such an EDTA experiment in 10 years. Additionally, the trial defense counsel presented Raleigh Johnson, the owner of Mr. Avery's trailer, who testified that he observed that the cut on Mr. Avery's finger was present prior to October 31, 2005. Discovery of RAV4 key with Mr. Avery's DNA. Trial defense counsel failed to subpoena the bookcase to demonstrate for the jury the credibility of Sergeant Colburn's description of dislodging the key from the back of the bookcase and having it migrate to the northwest side of the bookcase by Mr. Avery's slippers. Mr. Avery's trial defense counsel did not have a DNA or trace expert examine the key. Mr. Avery's DNA on hood latch. Trial defense counsel did not have a DNA expert analyze the swab from the hood latch to determine if the quantity of DNA was consistent with an individual opening a hood latch one time. Trial defense counsel did not have a trace expert analyze the hood latch to determine if it had actually swabbed a hood latch. Bones in Mr. Avery's burn pit. Defense trial counsel claimed the bones of Ms. Halbach were planted in Mr. Avery's burn pit, but presented no evidence as to who planted the bones, when, or how they were planted. Dr. Fairgrieve would not offer an opinion as to whether Mr. Avery's burn pit was the primary location of the body burning and admitted that he had only looked at photographs and not examined the actual bones. Ms. Hallback's DNA on bullet. Trial defense counsel did not have a ballistics, trace, or DNA expert conduct experiments or microscopically examine number FL. Trial defense counsel speculated that because Ms. Culhane had contaminated the control sample for number FL, she may also have transferred Ms. Hallback's DNA onto FL. Trial defense counsel stated that Ms. Culhane had Ms. Hallback's DNA from the RAV4 cargo area, quote, sitting right there on her bench, unquote. So, quote, you can't tell how and whether Teresa Hallback's DNA ended up there in the same extraction mechanism, unquote. Third-party suspects. On January 30, 2007, the trial court precluded Mr. Avery from offering direct evidence, quote, that a third party other than Brendan Dassey participated in the commission of the crimes charged in the amended information, unquote. Trial defense counsel named 30 third-party suspects pursuant to State versus Denny, which included Mr. Tadek, Andre Martinez, James Kennedy, Charles Avian, Mr. Fabian, Earl, Blaine, Bobby, and Brian Dassey. The trial court found, quote, in the absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material connecting a third person to the crime. The court simply finds nothing in the offer made by the defendant that goes beyond the level of speculation, unquote. The trial court did allow trial defense counsel in his closing to mention, quote, other suspects, unquote, that were being investigated by Special Agent Thomas Fassbender and Investigator Uyghur. Trial defense counsel criticized the investigation of these suspects by pointing out their suspicious behavior. Trial defense counsel named George Zipperer, Ms. Hallback's ex-boyfriend Ryan Hilgas, Ms. Hallback's roommate, Scott Blodorn, Ms. Hallback's former married lover, Bradley Check, and Ms. Hallback's business associate, Thomas Pierce. Specifically, trial defense counsel pointed out Mr. Zipperer's strange behavior, the lack of alibi for Mr. Hilgas, Mr. Blodorn, and Mr. Check, and the failure for 4 days of Mr. Blodorn and Mr. Pierce to report Ms. Hallback missing. On March 18, 2007, Mr. Avery was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin Statute 940.01, and a felon in possession of a firearm, contrary to Wisconsin Statute 941.29. The jury found Mr. Avery not guilty of mutilation of a corpse. Post-conviction and direct appeal. On August 3, 2007, Suzanne Hagopian and Martha Askins, quote, prior post-conviction counsel of the Wisconsin State Appellate Defendant's Office, were appointed as direct appeal and post-conviction counsel. On June 29, 2009, they filed a motion for post-conviction relief on Mr. Avery's behalf, seeking a new trial on grounds that, 1, the trial court improperly excused a deliberating juror, and 2, the trial court improperly excluded evidence of third-party liability. Mr. Avery's motion included a claim of ineffective assistance of counsel on the jury issue. On September 28, 2009, an evidentiary hearing was held. On October 29, 2009, a brief in support of Mr. Avery's post-conviction motion was filed. On January 25, 2010, the motion for post-conviction relief was denied by the Honorable Patrick L. Willis in a written order. There was an appeal from that decision, and that decision was affirmed by the appellate court on August 24, 2011. And the footnote on this page says, this court, in its 2011 opinion, erroneously stated that, quote, Stephen Avery was convicted as a party to the crime of the first-degree intentional homicide of Teresa Hallback, unquote. The party to a crime language was in the second amended information, which the state had to dismiss when Brendan recanted his confession. The information upon which Mr. Avery was convicted refers to the original information and did not have the language, quote, party to a crime, unquote. Now we are on page 43 of 150. On December 14, 2011, the Wisconsin Supreme Court denied the petition for review pursuant to 808.10. Pro se post-conviction 974.06. On February 14, 2013, Mr. Avery filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin Statute 974.06. The motion was denied by the Honorable Judge Angela Suckowitz, Judge Flowers, on November 23, 2015. Mr. Avery claimed that trial counsel failed to A, raise a Sixth Amendment violation regarding Mr. Avery's jail conversations with his trial attorneys. B, suppress evidence obtained by invalid search warrants. C, sever the felon in possession of a firearm charge. D, develop an argument based upon available information that the state had planted evidence. E, strike biased juror Carl Wardman. Oh, Carl Wardman. Carl Wardman worked for the not only did he work for the Manitowoc County Sheriff's Department, his son was a deputy. And so when you Google Stephen Avery and you see the picture of him in handcuffs where he's got a female and male officer on either side of him, the male is Carl Wardman's son. Okay, sorry. And F, investigate relevant material issues. Mr. Avery claimed that his appellate counsel failed to argue, quote, retroactive misjoinder, unquote. Additionally, Mr. Avery claimed the trial judge was biased and both trial and appellate counsel failed to raise the issue of the state, commenting on Mr. Avery's silence in the state's closing argument. On November 23, 2015, the court denied all of the claims in Mr. Avery's motion as lacking any merit. Mr. Avery filed a notice of appeal on December 3, 2015. Motion for scientific testing 971.23, 974.07, and second post-conviction 974.06. Mr. Avery obtained current post-conviction counsel in January of 2016. On August 26, 2016, current post-conviction counsel filed a motion for post-conviction scientific testing pursuant to Wisconsin statutes, blah, blah. On September 12, 2016, the appellate court granted current post-conviction counsel's motion to stay Mr. Avery's appeal and remanded the case to the circuit court, which entered an order on November 23, 2016 for specific items to be tested. Pursuant to that order, scientific testing was performed and current post-conviction counsel filed a motion for post-conviction relief on June 7, 2017, and also filed a motion to dismiss Mr. Avery's pro se appeal, which was pending with the appellate court. That motion was granted on July 24, 2017. On September 18, 2017, on September 18, 2017, Mr. Avery's current post-conviction counsel reached an agreement with the state to allow the June 27 motion to be amended without opposition, to add and remove claims, and for additional scientific testing of evidence. Scheduling for a potential evidentiary hearing in the spring of 2018 was discussed because both sides believed the circuit court would grant an evidentiary hearing on Mr. Avery's claims. On October 3, 2017, prior to the state working out the logistics of the RAV4 testing, the circuit court issued an order summarily denying Mr. Avery's June 7, 2017 motion for post-conviction relief without ordering the state to respond to Mr. Avery's motion or granting an evidentiary hearing. On October 6, 2017, current post-conviction counsel filed a motion to vacate the October 3 order, informing the court of the September 18 agreement between Mr. Avery's counsel and the state for additional scientific testing and an amendment to current post-conviction counsel's motion for post-conviction relief. When the circuit court did not timely respond to current post-conviction counsel's October 6 motion to vacate, current post-conviction counsel filed a motion for reconsideration on October 23, 2017, and several supplements thereto on October 31 and November 1, 2, 16, and 17, 2017. My dog's begging me to go out, but the motion to reconsider and its supplements contained new evidence that developed after the June 7, 2017 filing and after the filing of the original motion to reconsider on October 23, 2017. On November 17, 2017, current post-conviction counsel filed a timely notice of appeal from the October 3, 2017 order. The circuit court did not rule on the October 6, 2016 motion to vacate until November 28, 2017, when it denied current post-conviction counsel's motion to vacate the October 3, 2017 order in motion to reconsider and its supplements. Current post-conviction counsel filed an additional timely notice of appeal on November 30, 2017 from the circuit court's order of November 28, 2017. On May 2018, current post-conviction counsel submitted a motion to supplement the record on appeal with a CD disclosed for the first time by the state on April 17, 2018, which current post-conviction counsel contends contains impeaching and or exculpatory evidence. The appellate court remanded to the circuit court to, quote, conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the supplemental post-conviction motion is filed, unquote. On September 6, 2018, after the court's deadline for decision had elapsed, the circuit court, without conducting any proceedings, denied, quote, all motions submitted by the defendant on or after July 6, 2018, unquote. On January 24, 2019, current post-conviction counsel submitted a motion to the appellate court to supplement the record. Christy says everybody is saying go let my dog out. So hold on, I'll let my dog out. Come on, who wants to go outside? And I grabbed some water. All right, back at it. Thank you, Christy, for letting me know. Where was I? Okay, so dated September 20, 2011, which, according to Mr. Avery's current post-conviction counsel, reflects law enforcement's transfer of multiple human bones from the Manitowoc County gravel pit to Whiting Funeral Home for return to Hallback's family. Mr. Avery alleges that the state violated its statutory duty to preserve as evidence, and the actions violated Mr. Avery's constitutional due process rights. On February 25, 2019, the appellate court granted the motion and allowed current post-conviction counsel to file a supplemental post-conviction motion. The appellate court further ordered the circuit court to, quote, conduct any proceedings necessary to address the claims raised in the supplemental post-conviction motion and to enter an order containing its findings and conclusions, unquote. On August 9, 2019, the Circuit Court, without conducting any proceedings, denied the motion, finding, quote, that the defendant has failed to meet his burden to establish that Wisconsin Statutes 968.205 has violated or his constitutional rights were violated under the provisions of Youngblood versus Arizona. Mr. Avery now appeals. All right, so now here's where we get to what they want for today. So that starts on page 48 of 150. Starts with argument. The Circuit Court abused its discretion in denying Mr. Avery's motion to vacate its October 3, 2017 order and allowing additional scientific testing. On September 18, 2017, a meeting took place in Madison, Wisconsin, in which Kathleen Zellner and Douglas Johnson, current post-conviction counsel, together with prosecutors Thomas Fallon, Norman Gahn, and Mark Williams, the prosecutors, reached an agreement regarding additional forensic testing. 1. The RAV4 would be made available to current post-conviction counsel's experts, Dr. Carl Reich and Dr. Christopher Palanik, for a complete examination of the interior and exterior of the RAV4 for additional forensic evidence to be tested. The examination was to take place at the Calumet County Sheriff's Department, who has possession of the RAV4. In addition to gathering forensic evidence from RAV4's interior and exterior, the agreement provided for collecting swabs for testing from the following items: battery cables, bar under the driver's seat, hood latch, interior hood release. The prosecutors also agreed that Mr. Avery would be allowed to do the following: conduct more sensitive DNA testing on the license plate, conduct DNA testing of the lug wrench, and Dr. Steven Symes and Dr. Eisenberg would conduct a microscopic examination of the pelvic bones, number 8675, discovered in the Manitowoc County gravel pit to determine if they were human in origin. When current post-conviction counsel inquired as to whether the Circuit Court should immediately be informed of the agreement, Prosecutor Fallon stated that once he had finalized the scheduling of the RAV4 examination with the CCSD, a stipulated order would be presented to the Circuit Court, similar to the original stipulated order for independent scientific testing that was presented by the parties to the Circuit Court and entered on November 23, 2016. Prosecutors stated that they would schedule the RAV4 testing in the very near future, before the weather worsened. The parties also agreed that, at that time, they would propose dates for a potential evidentiary hearing. Neither side anticipated the Circuit Court filing its order prior to the time Mr. Avery could notify the court of the matters set forth herein. On October 3, 2017, the Circuit Court entered an order dismissing Mr. Avery's Wisconsin Statute 974.06 motion for relief. On October 6, 2017, current post-conviction counsel spoke to prosecutors and informed them that Mr. Avery was filing a motion to vacate the October 3, 2017 order. Prior to filing the motion, current post-conviction counsel presented the motion to prosecutors. The prosecutors agreed to the factual accuracy of the representations regarding the content of the September 18, 2017 meeting made in the motion. The state did not file an objection to the motion. The court did not issue its ruling until November 28, 2017. The Circuit Court denied Mr. Avery's motion for relief from judgment. The parties were not required to submit proposals for further specific testing for approval by the Circuit Court because of the prior order of the trial court, entered on April 4, 2007, 10 years earlier. Therefore, the Circuit Court clearly abused its discretion when it denied Mr. Avery's motion for relief from judgment. Next section is titled Standard of Review. An order granting or denying relief under Wisconsin Statute 806.07 will not be reversed on appeal unless there has been a clear abuse of direction. Mullen versus Coulon. Under Wisconsin statute, blah, blah, a defendant must first file a motion with the trial court to obtain relief from a judgment or order before appealing. Otherwise, the issue will be deemed unreviewable. It is undisputed that 806.07 governs civil actions and proceedings under 974.06 are properly considered civil in nature. B, the circuit court erred in not complying with the prior trial court order regarding scientific testing. The original stipulated order for independent scientific testing was presented by the parties to the circuit court and entered by it on November 23, 2016. The order made express reference to and relied upon the trial court's April 4, 2007 order on preservation of blood evidence and independent defense testing. The trial court entered the order in 2007, contemplating future scientific developments for DNA testing. In 2007, the 2007 order provides the pertinent part, quote, the state shall preserve indefinitely until further order of this court all blood stains that the state believes contain Stephen Avery's DNA and that were found in or on Teresa Hallback's vehicle in a condition suitable for further scientific testing. Sorry, somebody's calling me. The defendant, Stephen A. Avery, or any lawyer representing him, may at any time submit the blood stains, swabs, and items described above to any laboratory or person the defense may choose for independent scientific testing pursuant to Wisconsin statute, blah, blah. And now this is emphasized, without further order of this court. For purposes of illustration, not limitation, this paragraph expressly contemplates independent defense testing during any state or federal post-conviction proceedings, if any, or after any such post-conviction proceedings. As demonstrated by the trial court's April 4, 2007 order, Mr. Avery was given the authority was given the authority at, quote, any time to submit items of evidence for DNA testing. And now hold on, I think I have to answer this. It's on Saturday. I'm doing a live video now. I'll call after. Okay. When current post-conviction counsel entered into the stipulated order in 2016 with the state, the testing items were expanded to include the RAV4 key and the bullet FL. As discussed previously, the September 18, 2017 agreement between the parties expanded the items for DNA testing even further, but is compliant with the spirit of the April 4, 2007 order, which allowed Mr. Avery to seek additional DNA testing as DNA technology improved. Any DNA evidence from a complete forensic examination of the RAV4 would be consequential to Mr. Avery's conviction because the state's case hinged on the assumption that Mr. Avery's and Ms. Hallback's biological material, to the exclusion of all others, was present in the RAV4. If biological material from another individual with no innocent explanation for having been in the RAV4 is detected therein, That exculpatory evidence would create a reasonable probability of a different outcome in satisfaction of State versus O'Brien, because it would support the third party and frame up defenses Mr. Avery has advanced since before his 2007 trial. Detected on reexamination, quote, must be considered after the other evidence presented at trial to determine if it is reasonably probable that the movement would not have been convicted, unquote. Now we're on page 53 of 150, and we've been going for over an hour. Male DNA was detected on the RAV4 license plates, but was insufficient for a profile. However, with more sensitive and advanced DNA testing developed since the trial, a full profile may be detected, which would rule out Mr. Avery as the person who removed the license plates from Ms. Halbach's vehicle. Since it is undisputed that the license plates were removed from Ms. Halbach's vehicle after her murder, the detection of a full DNA profile would be consequential to Mr. Avery's conviction and would satisfy O'Brien. And if Mr. Avery is excluded from the profile, it would create a reasonable probability of a different outcome. Pursuant to Wisconsin statute, blah, blah, a criminal defendant may move the circuit court for post-conviction testing when the movement can show that the evidence is relevant to the investigation or prosecution, the evidence is in the possession of the government agency, and that the evidence has not previously been subjected to DNA testing, or, if previously tested, may be tested using a newer technique. The Wisconsin statute provides as follows, quote, if the evidence has previously been tested, it may now be subjected to another test using a scientific technique that was not available or was not utilized at the time of the previous testing, and that provides a reasonable likelihood of more accurate and probative results, unquote. The circuit court clearly abused its discretion in not vacating its October 3, 2017 order in light of the explicit language of the trial court's April 4, 2007 order. Moreover, the parties reached an agreement in reliance on the circuit court's April 4, 2007 order, which provided the parties with the authority to test forensic evidence without seeking an additional order. Without seeking an additional court order. Mr. Avery should be relieved of the October 3 order because he has provided sufficient reason to justify that the circuit court reached an erroneous conclusion of law by not recognizing the existence of the April 4, 2007 order. Because the conviction of Mr. Avery was primarily based on forensic evidence, further forensic testing, as agreed upon by the parties, has a reasonable likelihood of yielding exculpatory evidence that is consequential to Mr. Avery's conviction and would create a reasonable probability of a different outcome. It is noteworthy that current post-conviction counsel has paid for all the testing done to date and intended to pay for testing performed pursuant to the parties' September 18, 2017 agreement. So no financial burden is imposed upon the state. It is a clear abuse of discretion for the circuit court to deprive both sides of additional testing, which will be performed at Mr. Avery's expense. 2. The circuit court abused its discretion in summarily dismissing Mr. Avery's second motion pursuant to Wisconsin Statute 974.06 without addressing the 5 Brady claims raised, and in subsequently denying Mr. Avery's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution. Standard to review. To establish a Brady violation, the defendant must demonstrate that 1, the prosecution suppressed evidence, 2, the evidence was favorable to the defense. And then the post note down here says current post-conviction counsel has expanded $292,197.13 on experts as of the filing of this brief. And 3, the evidence was material to an issue at trial. This court reviews de novo whether the facts of a case establish a Brady violation. There can be a due process violation, quote, irrespective of the good faith or bad faith of the prosecution, unquote. Quote, the prosecution's duty to disclose evidence favorable to the accused includes the duty to disclose impeachment evidence as well as exculpatory evidence, unquote. The circuit court failed to address any of Mr. Avery's 5 Brady violations filed in his motion to reconsider and its supplements, but concluded, quote, there is no argument or showing of a sufficient reason as to why these issues could not have been raised in prior motions. Without such sufficient reason, these arguments are precluded from any subsequent motion, unquote. B, Brady violation regarding Mr. Romlo. The circuit court failed to recognize that it is axiomatic, that's a different word for me, that the discovery of a Brady violation subsequent to filing a motion pursuant to blah blah constitutes a sufficient reason for failing to raise the issue in a prior motion. Noting a defendant's unawareness of the legal basis of his claim may constitute a sufficient reason in satisfaction of statute blah, blah, blah. The defendant's unawareness of the factual basis of his claim was, quote, inextricably intertwined, unquote, with the legal basis of his claim, unquote. Trial defense counsel made 2 specific requests pursuant to Wisconsin statute blah blah for all exculpatory evidence and or information within the possession, knowledge, or control of the state, which would tend to negate the guilt of the defendant, or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. A second request was made by trial defense counsel for Brady material immediately before trial on January 18, 2007. In July of 2017, a new witness, Kevin Romlo, came forward and described the most significant Brady violation in the case to that point in time. Clearly, current post-conviction counsel could not have included Mr. Romlo's affidavit in the June 7, 2017 filing, since Mr. Romlo had not yet come forward with evidence that establishes a Brady violation. Mr. Romlo has provided an affidavit and supplemental affidavit to current post-conviction counsel. In these affidavits, Mr. Romlo described observing Ms. Halbach's RAV4 parked at the turnaround on State Highway 147 and the East Twin River Bridge on November 3 and 4, 2005. On November 4, Mr. Romlo disclosed his observation about seeing the vehicle during a conversation with Sergeant Colborn at the Senex station in Michigan. Immediately prior to the conversation with Sergeant Colborn, Mr. Romlo observed the missing person poster of Ms. Halbach posted on one of the doors to the Senex station and recognized the vehicle on the poster as the vehicle he had seen 2 days in a row at Highway 147 and the East Twin River Bridge. On December 12 and 19, 2016, after watching the Netflix documentary Making a Murderer more than a year after its release, Mr. Romlo, who lived in Michigan, sent text messages to Scott Tadek telling him that he recognized Sergeant Colborn from the documentary and that Sergeant Colborn was the officer with whom he spoke on November 4, 2005 at the Senex station in Michigan. Mr. Tadek never responded to Mr. Romlo's specific request to be put into contact with Brendan's attorneys. Mr. Romlo's observation of the RAV4 on November 3 and 4, 2005 is material to the defense theory that evidence was planted to frame Mr. Avery. If the RAV4 was spotted at the turnaround on Highway 147 on November 3 and 4, 2005, then it must have been moved and planted to the Avery property before it was discovered on November 5, 2005. Clearly, this information supports trial defense counsel's theory that the RAV4 was planted on the Avery salvage yard on November 5, 2005, and that, contrary to the state's theory, it was possible to access the Avery property and plant the vehicle. Mr. Romlow's testimony would have established that Mr. Avery was framed for Ms. Halbach's murder. A key issue in determining if the RAV4 was planted was the credibility of Sergeant Colborn. At trial, Sergeant Colborn testified that he was not looking at the RAV4 when he made his dispatch call regarding the vehicle's license plate number. The state argued that Sergeant Colborn made the call on November 3 to confirm the accuracy of the RAV4 license plate number previously given to him that day. Because trial defense counsel did not have a police report documenting Sergeant Colborn's conversation with Mr. Romlow, they could not impeach Sergeant Colborn regarding his denial. If trial defense counsel had been aware of the conversation between Sergeant Colborn and Mr. Romlow could have been called as a witness to impeach Sergeant Colborn and Mr. Romlow. Sergeant Colborn would have been discredited, and the jury would have been provided material information proving that the RAV4 was originally at the turnaround on Highway 147 and was subsequently planted on the Avery property. The United States Supreme Court in Weary versus Kane held, quote, Brady applies to evidence undermining witness credibility. Evidence qualifies as material when there is, quote, any reasonable likelihood, unquote. It could have, quote, affected the judgment of the jury, unquote. To prevail on his Brady claim, Weary need not show that he, quote, more likely than not, unquote, would have been acquitted had the new evidence been admitted, unquote. The only evidence the state presented that the RAV4 was not planted on the Avery property on October 31, 2005 was the testimony that the 15 to 20 foot high berm prevented access to the Avery property where the RAV4 was found. However, Prosecutor Kratz concluded the weakness of that argument when he admitted in his closing that the RAV4, quote, couldn't be driven into that property unless somebody knew that property, unquote. And the footnote says the chronology of the 30 tracks of the MCSD calls to dispatch demonstrates that the Sergeant Colborn's call was made on November 4, 2005. The only other evidence presented by the state that the RAV4 never left the Avery property after October 31, 2005 was Bobby's testimony that the RAV4 was still present when he left the Avery property at 2:45 p.m. Trial defense counsel presented no evidence from witnesses that the RAV4 was planted and simply argued in the closing that there were, quote, lots of ways to get in and for someone to plant the vehicle, unquote. The failure of the state to disclose Mr. Romlow's interview with Sergeant Colborn is material because it would have established that the vehicle not only left the Avery property, but that it was brought back to the property and planted. If the RAV4 left the property, the state's theory that Ms. Halbach's murder occurred exclusively on the Avery property would be completely debunked. If Mr. Romlow's interview with Sergeant Colborn had been disclosed to trial defense counsel and revealed to the jury by having Mr. Romlow testify to impeach Sergeant Colborn, there is a reasonable probability that the result of the proceeding would have been different. A, quote, reasonable probability, unquote, is a probability sufficient to undermine confidence in the outcome. And the post note says, current post-conviction counsel has obtained an affidavit from a second witness, Paul Burdick, on June 28, 2018, who also saw the RAV4 parked at the turnaround on 147 on October 31, 2005. Although this witness did not report this information to the police, he does corroborate Mr. and it doesn't have the rest on there. Because we just go on to, now we're on page 60 of 150, and it starts with C, Brady violation regarding Mr. Radant. The state committed a second Brady violation related to the RAV4 being planted when it failed to disclose information in a police report that the Department of Justice investigators provided to Joshua Radant, who Carla got to file a trespassing charge against me, about its belief that the RAV4 was planted on the Avery property. Mr. Radant has provided an affidavit to current post-conviction counsel that states the following, quote, at that time, around November 5, 2005, I was told by the Department of Justice agents that they believed Teresa Hallback's vehicle was driven to the Cuss Road cul-de-sac by driving west through an empty field, then south down the gravel road past the hunting camp until reaching an intersection with a gravel road that ran northeast into the Avery property. They told me that they believed Teresa Hallback's vehicle turned northeast onto the gravel road and entered the Avery property at its southwest corner. Let me highlight that again. Radant, however you pronounce it, who owns the quarry that is right behind where Teresa's vehicle was planted at the salvage yard, and he owns the deer camp, was told by Department of Justice agents that they believed her car traveled through there to go and park where it was found. So he was told by law enforcement. Let me continue. I just needed to spotlight that for you, that he was told that by agents. DOJ investigators never authored a report about the information they provided to Mr. Radant. Mr. Radant's affidavit is similar to Mr. Romlow's affidavit in that it directly contradicts the state's denial that the RAV4 was planted. Furthermore, Mr. Radant's affidavit contradicts the state's representation to the jury that the Avery property was inaccessible from the Radant pit. Mr. Radant could have been called as a witness to refute the state's claims that the RAV4 was not planted and to impeach the statements about the inaccessibility of the Avery property from the Radant gravel pit. And then the post note says, Romlow's claims that the RAV4 was moved from the Avery property and planted there before November 5, 2005. D, Brady violation regarding original flyover video taken on November 4, 2005. On November 4, 2005, Wendy Baldwin, she's the one that you can hear her when they were searching Stephen's trailer, say, are there any, take any shoes? So if there's any other unsolved crimes, and she laughs that he won't be able to make the looking at the letter, that he won't be able to make that event now. That's Wendy Baldwin. She's a peach. And CCSD Sheriff Jerry Poggle conducted a flyover searching for the RAV4. They were in the air for around 4 hours, yet produced only 3 minutes. Flying for 4 hours, only show you 3 minutes of it. They were in the air for around 4 hours, yet produced only 3 minutes of flyover footage. Prosecutor Kratz made a material admission when he told the jury that the RAV4 was not visible in the flyover video because he claimed the vehicle was covered with branches. However, the edited version did not show the southeast corner of the salvage yard at all, much less a vehicle covered with branches. Therefore, a reasonable inference from this statement to the jury is that Prosecutor Kratz saw the unedited flyover video. If the video was intentionally edited to delete the footage of the southeast corner, this is a Brady violation because the issue of whether the RAV4 was planted was material to Mr. Avery's conviction. An evidentiary hearing is necessary to determine the credibility of the state's claim that only 3 minutes of flyover footage exists and that there were no deletions of the flyover video. E. Brady violation regarding zipper voicemail. Ms. Hallback left a voicemail on the zipper answering machine when she could not find their residence on October 31, 2005. On November 3, when the zippers were interviewed at 9:30 p.m., they told the investigators about Ms. Hallback's message. On November 3, 2005, Ms. Hallback's voicemail was listened to by Detective Remaker of the MCSD and copied by MCSD Detective Dennis Jacobs onto a CD. The CD was never turned over to trial defense counsel and has allegedly disappeared. Oh, whoops. On April 20, 2017, Prosecutor Fallon confirmed by letter to current post-conviction counsel that neither Calumet nor the Manitowoc Sheriff's Departments have been able to locate the CD of Ms. Hallback's voicemail. The contents of the zipper voicemail may have contradicted the timeline established by the state that Ms. Hallback's last stop was the Avery salvage yard. Suspiciously, the state never played the recording of the voicemail for the jury, but they attempted to introduce its contents through Joellen Zipperer. Ms. Zipperer's unimpeached testimony on the contents was that Ms. Hallback came to the Zipperer property between 2 and 2:30 p.m. Corroboration of the assertion that the voicemail would have contradicted the state's timeline is found in a recorded conversation between investigator Wiegert and Detective Remaker on November 5, 2005 about the sequence of Ms. Hallback's appointments on October 31, 2005. In that conversation, which occurred after interviews with Mr. Schmitz, Mr. Avery, and Mr. Zipperer, they concluded that Ms. Hallback's first appointment was with Mr. Schmitz, her second appointment was with the Averys, and her third appointment was with the Zipperers. It is reasonable to infer that Investigator Wiegert and Detective Remaker based their conclusion on the zipper voicemail left by Ms. Hallback, which was listened to by investigators on November 3, 2005 at the Zipper residence, recorded on a CD on November 6, 2005, and withheld from trial defense counsel. Clearly, the Zipper CD is material evidence that could have been used to impeach Ms. Zipperer on the timeline and would have refuted the state's entire theory that Ms. Hallback's last stop was at the Avery property. F. Brady violation regarding Ms. Heidel. Ms. Heidel has provided current post-conviction counsel with an affidavit that states that she had a telephone conversation with Ms. Hallback on October 31, 2005 at 11:35 a.m. while Ms. Hallback was driving. Ms. Hallback pulled her vehicle over to make notations on her day planner as she engaged in conversation with Ms. Heidel. There is no evidence that Ms. Hallback returned home after this conversation. According to Ms. Heidel's affidavit, she reported this conversation to law enforcement, including the fact that Ms. Hallback was driving and pulled over to check her schedule and made notations about the conversation. No report of the Heidel-Hallback conversation was ever turned over to Mr. Avery's trial defense counsel, and the state never mentioned Ms. Heidel's call to Ms. Hallback at trial. It is a reasonable inference that Ms. Hallback's day planner was in the RAV4 with her at the time of her murder. Ms. Hallback's ex-boyfriend, Mr. Hilgas, was in possession of the day planner after Ms. Hallback's murder, according to one of Ms. Hallback's friends. Items from the RAV4 has particular relevance since many things were missing that should have been present in the vehicle, such as Ms. Hallback's purse, wallet, driver's license, money, schedules, receipts, maps, Toyota Master Key, house key, and other items related to her activities with Auto Trader or her hustle shots. It is undisputed that items were removed from her vehicle to conceal the crime. Anyone in possession of those items would qualify as a Denny suspect because it would establish a direct link to the crime. If Ms. Heidel's report of her telephone conversation with Ms. Hallback had been disclosed to trial defense counsel by the state, it could have been used to directly connect Mr. Hallgas to the crime and firmed up Mr. Avery's theory and taken it beyond mere speculation. G. Brady violation regarding Dassey Yanda CD. On April 17, 2018, current post-conviction counsel received the Detective Michael Velli CD for the first time from Prosecutor Fallon. The CD contained Detective Velli's forensic examination of the Dassey Yanda computer, also known as the Bobby computer. On May 18, 2018, current post-conviction counsel filed a motion to supplement the record to the appellate court with the CD. On June 11, 2018, the appellate court remanded the case to the circuit court with instructions that, quote, this appeal is remanded forthwith to the circuit court to permit Mr. Avery to pursue a supplemental post-conviction motion in connection with Avery's receipt of previously withheld discovery or other new information, unquote. The appellate court further ordered, quote, that the circuit court shall conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the supplemental post-conviction motion is filed, unquote. On September 6, 2018, the circuit court denied Mr. Avery's motion to supplement, holding that, quote, the defense was in full possession of the same information as the prosecution via the 7 CDs turned over pursuant to discovery, unquote. The circuit court also determined that the CDs were turned over to trial defense counsel 2 months prior to trial. Therefore, the circuit court held that Mr. Avery had failed to meet his burden of showing the evidence was suppressed. The Dassey Yanda CD contained unique information not previously disclosed. Quote, the Brady obligation, quote, does not cease to exist at the moment of conviction, unquote, but, quote, continues to apply, unquote, to the plaintiff's post-trial assertion that he, quote, did not receive a fair trial because of the concealment of exculpatory evidence known and in the existence at the time of the trial, unquote. The circuit court erred when it concluded that the CD contained exactly the same information as the 7 DVDs, so nothing was suppressed. The CD contained unique information derived from Detective Velli's information of specific Hallback crime scene facts to the raw data in the 7 DVDs. The 7 DVDs did not contain the results of Detective Velli's unique search terms found exclusively on the CD. And there's Jerry Buting just tweeted this that we're reading now. Those search results are as follows. 2,632 search results for the terms blood, body, bondage, bullet, cement, DNA, fire, gas, gun, handcuff, journal, MySpace, news, RAV, stab, throat, and tires. It is undisputed that the results of those unique word searches of Detective Velli were suppressed and withheld from trial defense counsel, prior post-conviction counsel, and current post-conviction counsel until April 17, 2018. Because there is no way prior to April 17, 2018 that current or prior counsel could have guessed the scientific search terms for the results which Detective Velli obtained, Mr. Avery was deprived of this material information, which could have established a direct link between the specific evidentiary terms related to the Hallback murder and the searches performed on the Dassey Yanda computer. The CD also contained the state's recovered pornography images relevant and material to the Hallback murder. The CD refined the 14,099 images on the 7 DVDs and recovered 1,000 2,625 violent pornography images, which had been deleted. The, quote, recovered porn, unquote, depicted violent images of the torture and mutilation of young females, many of whom bore a striking resemblance to Ms. Hallback. The 1,625 images of 1,625 images, there's a little more singing for you, of violent pornography could have established motive for trial defense counsel's Denny motion. Failure to disclose CD prior to Denny ruling, and we are on page 67 of 150. The circuit court ignored current post-conviction counsel's argument that trial defense counsel was completely impaired in its ability to effectively identify a motive in its Denny motion, filed on January 8, 2007, before trial. Noting evidence may be considered impermissibly withheld if the prosecution failed to disclose the evidence before it was too late for the defendant to make use of the evidence. The circuit court abused its discretion when it ignored Mr. Avery's argument that his Denny motion was compromised by the late disclosure of the state and chose to focus only on the disclosure of the 7 DVDs 2 months prior to trial. Trial defense counsel, Mr. Buting, provided an affidavit to current post-conviction counsel explaining the effect of the late disclosure of the success of trial defense counsel's Denny motion regarding establishing the motive of Bobby. Mr. Buting states, quote, "We established that he, Bobby, had access and opportunity to have committed the crime, but the court ruled no motive was established and therefore denied the Denny motion as to Bobby Dassey and others. If there was anything that was on the CD investigator report from Dr. Velli that would have linked Bobby Dassey to the violent porn images found on the Dassey computer, we could have included such information in our Denny motion. Such information could have strengthened Bobby Dassey as a possible suspect who may have sexually assaulted and killed Ms. Hallback and specifically would have provided evidence of a motive," unquote. Misleading nature of the disclosure by Prosecutor Kratz. The state admits that the CD was suppressed from May 10, 2006 until the state disclosed it to current post-conviction counsel on April 17, 2018, exactly 4,360 days after it was created by state's forensic examiner. The circuit court ignores Mr. Avery's argument that his trial defense counsel was deliberately misled by Prosecutor Kratz. In Prosecutor Kratz's December 14, 2006 letter, he did not disclose the CD, but did disclose the December 7, 2006 Thomas Fassbender report. The Fassbender report was prepared 218 days after Detective Velli's final investigative report was completed for the state on May 10, 2006. Mr. Strang provided an affidavit and raised additional issues about the state's non-disclosure of the CD. On January 25, 2007, on the eve of trial, Attorney Strang received a document entitled, quote, "Stipulation Project," unquote, from Prosecutor Kratz. In that document, paragraph R stated, quote, "Computer analysis of Steve, Teresa's, and Brendan's computer, Mike Velli," and he spelled Velli's name wrong, "of the Grand Chute PD, analyzed the hard drives of these three and found," and now this is emphasized, "nothing of evidentiary value. We may wish to introduce the fact that they looked. This strip eliminates Officer Velli, spelled wrong, as a witness," unquote. Mr. Strang's affidavit states in relevant part, quote, "I accepted without challenge Ken Kratz's assertion in a January 25, 2007 email to me that Veli's analysis of, quote, Steve, Teresa's, and Brendan's, unquote, computers yielded, quote, nothing much of evidentiary value, unquote. With the belated production of the Veli forensic analysis to Mr. Avery's current lawyers in April 2018, it now appears to me from materials that Ms. Zellner and co-counsel have filed that the Veli forensic analysis, in fact, did include much of evidentiary value in direct contradiction to Mr. Kratz's claim. Given what I know now about the existence and content of the Veli forensic analysis, this looks to me like deceit. My firm and I did not have end case while representing Mr. Avery. I think that Mr. Buting did not either. So we could not review the data on the 7 DVDs given to us. Of course, we never got the Veli CD-ROM at all, unquote. The circuit court abused its discretion when it found the trial defense counsel had failed to exercise reasonable due diligence in the following ways. 1, failed to request access to the in-case program from the prosecution and, quote, was denied such access. 2, failed to request the missing CD when they had notice of the existence of the Veli CD via Vospender's report prior to trial. 3, failed to submit a motion to the court requesting additional time to review the newly discovered evidence. The Wisconsin Supreme Court in State versus Wierski has specifically rejected the imposition of a reasonable diligence standard on trial defense counsel. The Wisconsin Supreme Court specifically stated, quote, this court has never analyzed a Brady claim through the lens of, quote, reasonable diligence, unquote, and we decline to adopt that requirement now due to its lack of grounding in Brady or other United States Supreme Court precedent, unquote. In Banks versus Dretke, this United States Supreme Court specifically instructed, quote, a rule thus declaring, quote, prosecutor may hide, defendant must seek, unquote, is not tenable in a system constitutionally bound to accord defendants due process, unquote. The state should not be allowed to impose a reasonable diligence standard on trial defense counsel when the state suppressed the Veli CD for 12 years. Exclusive possession and control. The Wierski court specifically overruled prior Wisconsin cases which have imposed a requirement of exclusive possession and control of the material evidence by the state. The court specifically stated, quote, there is no express support in the United States Supreme Court's Brady jurisprudence for the limitation that only favorable material evidence in the, quote, exclusive possession and control of the state must be turned over to satisfy the due process obligations enunciated in Brady. This limitation further thwarts the purpose of the state's obligation under Brady to prevent the state from withholding favorable material evidence that, quote, helps shape a trial that bears heavily on the defendant, unquote, and, quote, casts the prosecutor in the role of an architect of a proceeding that does not comport with the standards of justice, unquote. We hereby overrule the holding set forth in Nelson and in its progeny that favorable material evidence is only suppressed under Brady where the withheld evidence is in the state's, quote, exclusive possession and control, unquote, unquote. Suspiciously, the Dassey Yanda CD was not accessible to trial defense counsel in the prosecutor's files because the CD was kept in the exclusive possession of Special Agent Vosspender. Even if trial defense counsel had searched the prosecutor files, they could not have discovered the CD. Quote, the knowledge of law enforcement officers may be imputed to the prosecutor. The test is whether by the exercise of due diligence, the prosecutor should have discovered it, unquote. Prosecutor Kratz knew that the CD was being kept separately from the other discovery and was in the sole possession of Special Agent Fassbender. The Wierski court noted, quote, the exclusion, possession, and control, reasonable diligence, and intolerable burden limitations distort the original Brady analysis and the purpose behind the prosecutorial obligations enunciated in Brady, unquote. The state, in its response to the motion to supplement, contended that multiple people had access to the computer, but current post-conviction counsel has provided sufficient evidence that it was only Bobby who had access to the computer during the day on weekdays. If the circuit court had conducted an evidentiary hearing, the issue of who had access to the Dassey Yanda computer during the week from 6:30 a.m. to 3:30 p.m. could have been definitively established through witness testimony. Current post-conviction counsel has asserted, based on her forensic computer expert Gary Hunt's analysis, and the violent searches primarily occurred on weekdays when only Bobby was in the residence. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. Mr. Avery only entered the residence with the permission of a Dassey family member. Mr. Avery worked during the weekdays from 8 a.m. to 5 p.m. Mr. Avery would be eliminated from all but 15 of the 128 searches at issue simply by having been arrested on November 9, 2005. Brendan would be eliminated from all but 26 of the 128 searches at issue by having been arrested on March 1, 2006. The Wisconsin Supreme Court in Harris stated, quote, here, the undisclosed information is not directly exculpatory in the same sense that DNA evidence might be, because the fact that BMM had alleged being previously sexually assaulted by her grandfather does not, in and of itself, tend to negate Harris's guilt regarding the separate assault that... My dog's barking. Hold on. Let me let my dog back in. All right, I am back. All right, similar to Harris, clicked the wrong thing here. Similar to Harris, of all of the witnesses in Mr. Avery's trial, Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Ms. Hallback never left the Avery property. Clearly, the jury was concerned about Bobby's credibility because he was one of only 2 witnesses whose testimony the jury requested to review during deliberations. Importantly, the CD timeline of internet searches directly contradicts Bobby's trial testimony. Okay, that on October 31, he was asleep from 6:30 a.m. to 2:30 p.m. Mr. Hunt determined that the internet on the Dassey Yanda computer was accessed on October 31, 2005, when only Bobby was home at 6:05 a.m., 6:28 a.m., 6:31 a.m., 7 a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. This impeaches Bobby's trial testimony that he was asleep from 6:30 a.m. to 2:30 p.m. On November 17, 2017, in a recent interview of Bobby by state investigators, Bobby claimed that the computer was located, quote, on a desk in the living room at the time, unquote. When Bobby was asked if the computer was ever located in his bedroom, he stated, quote, it was not, unquote. Bobby's statement is directly contradicted by the crime scene footage taken by Sergeant Tyson on November 12, 2005, which shows the computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother Blaine, who stated in his affidavit to current post-conviction counsel on June 25, 2018, that the computer was located in Bobby's room and Bobby was the primary user of it. The suppressed impeachment evidence on the Dassey Yanda CD is not, quote, largely cumulative of impeachment evidence petitioners already had and used at trial, unquote. Oh, no, that's not unquote. Nor is it simply impeachment evidence which only involved minor witnesses, unquote. As the Seventh Circuit points out in Sims versus Hyatt, the Brady materiality standard is not an admissibility test. Quote, it requires the court to gauge the potential effects on the outcome of the trial if the concealed information had been available to the defendant, unquote. Bobby was the primary witness for the state in establishing that Mr. Avery, and not he, was the last person to see Ms. Hallback alive. Knock it off. Sorry, somebody walking past my house, and that's why Mallory is whining. Bobby's credibility would have been severely diminished if the jury realized that Bobby was doing the following: searching and viewing numerous images of young females who bore a striking resemblance to Ms. Hallback, being tortured and sexually assaulted. Bobby was also lying to the jury about being asleep when he was doing internet searches. Stop. Bobby was searching for key terms relevant to the murder and created folders labeled Teresa Hallback and DNA. The violent pornography on the Dassey Yanda CD fulfills the Denny motive requirement and therefore meets the materiality standard of Brady. Because the circuit court erred in its finding that the 7 DVDs and CD were identical and therefore there was no suppression, it never reached the materiality issue of the CD's contents for Brady purposes. The Wisconsin statute provides that evidence of other crimes and or wrongs and or acts when offered as proof of motive, opportunity, intent, preparation, plan, knowledge, identity. Hold on. I'm supposed to be on a conference call. Let me message somebody. Okay. I can't be on today's call doing a live video on one of my cases. Sorry. Knowledge, identity, or absence of mistake or accident is admissible. The court versus Dressler versus McCautry. Yeah, Christy says, don't I have a doctor's appointment too? My doctor appointment's at 1:00, so I have an hour. So hopefully we've been on for 2 hours. Holy cow. And I have a doctor's appointment in 1 hour. The court in Dressler versus McCautry held that the acts admitted pursuant to this section were the defendant's possession of the pornographic videotapes and pictures. Those images depicting intentional violence were admitted as evidence of the defendant's motive, intent, and plan to murder the victim. The defendant in Dressler argued that the videotapes and pictures were irrelevant and constituted inadmissible propensity evidence. The Seventh Circuit disagreed, stating, quote, "The fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with that subject. A person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant," unquote. The Dressler court also rejected the defendant's argument that the videos and pictures were inadmissible propensity evidence and held that although evidence of the general character of a defendant is inadmissible to prove he acted in conformity therewith, the above exception from statute blah blah was deemed to apply. Dressler is persuasive authority that the same result should occur here. Ms. Halbach was killed in a violent and vicious manner. An obsession with images depicting sexual violence against women made it more likely that person would commit a sexual homicide. The violent sexual images were relevant to motive and would have resulted in trial defense counsel being able to establish motive to meet the Denny standard. As Mr. Avery's expert on sexual homicide, Ann Burgess, Ph.D., opines in her affidavit, relying upon 30 years of empirical research literature, there's a well-established causal connection between pornography consumption and violent behaviors. Now we're moving on to page 76 of 150. The Brady violations are newly discovered evidence that meet the Brady materiality standard. The decision to grant or deny a motion for a new trial based on newly discovered evidence is committed to the trial court's discretion. Quote, "When moving for a new trial based on the allegation of newly discovered evidence," you want me to cancel my doctor appointment? That I can't do, but it would be quick though. I'd only be gone for like 20 minutes. However, the overarching issue is that of newly discovered evidence under which all other issues on appeal are subsumed. We therefore examine it as such, unquote. In this case, and let me just add to that. I will do a live sometime tonight in the MAM gossip group where we can, we won't read through this. We'll now just discuss it. But that will be later after I'm for sure done reading it all in here in Stephen Avery Project, on Stephen Avery Project, and I'm done running a couple of errands. Okay, in this case, the contents of the Veely CD qualify as new evidence because, one, the CD was first disclosed to current post-conviction counsel in 2018 after being withheld for 12 years. Two, whatever duty Mr. Avery's trial defense counsel was under to investigate the Veely CD was superseded by the prosecution's ongoing duty to disclose and not suppress evidence. Three, the evidence, i.e. recovered pornographic images and 2,632 searches for keywords related to the murder of Ms. Halbach, provided by Detective Veely, was material to the trial court's consideration of Denny evidence related to Bobby. Four, and the evidence, specifically the aggregated pornographic images and Detective Veely's keyword searches, was not cumulative of the 7 DVDs tendered to trial defense counsel. Rather, this evidence constitutes a unique work product that is not merely a reevaluation of existing evidence or a new appreciation of known evidence. The Veely CD was material. In order for the defendant to prevail on the third component of the Brady analysis, and it's so funny that I have to keep reading Brady because now the conference call that I'm missing is with, I'm on the exec board of Brady United. So that's what keeps reminding me of I'm supposed to be on my Brady call. Of the Brady analysis, the suppressed evidence must be material. Quote, the evidence is material only if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different, unquote. It is not difficult to imagine what Mr. Avery's trial defense counsel could have done at trial with the knowledge of the violent pornography searches performed on the Dassey Yonda computer by Bobby, the state's primary witness. The court in Sims stated, quote, court must consider the overall strength of the prosecution case, the importance of the concealed witness's credibility to the prosecution case, the strength of the concealed impeachment material, and how the concealed material compares to other attacks the defense was able to make on the witness's credibility. Bobby's trial testimony was completely unrebutted by the defense. The suppressed impeachment evidence contained in the CD was material because it was, quote, it was not, quote, largely cumulative of impeachment evidence petitioners had already used at trial, unquote, and because the impeachment evidence was of the state's primary witness, Turner versus United States. Mr. Avery had a constitutionally guaranteed right to present a complete defense to the charges against him. Holmes versus blah, 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 these other cases citing. Mr. Avery was deprived of his constitutional right to present a complete defense because of the Brady violation committed by the state and failing to tender the forensic examination CD and report of Detective Veely entitled Dassey Computer Final Report Investigative Copy. The failure of trial defense counsel to have the benefit of using the CD to establish the Denny motive requirement is, as it pertained Bobby and or to impeach Bobby, the state's primary witness, deprived Mr. Avery of a meaningful opportunity to present a complete defense. The cumulative effect of the Brady violations establishes materiality. In addressing a Brady claim, the court is not to view each piece of suppressed evidence in isolation. Instead, the court is required to assess the cumulative impact of all the suppressed evidence to determine its materiality. Kiles versus Whitley. Suppressed evidence is material if its cumulative effect creates a reasonable probability of a different result at trial, and then a bunch of other cases. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. The Kiles court noted, quote, the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but whether in its absence he received a fair trial, understood as a trial resulting in a verdict worthy of confidence, unquote. A reasonable probability is lower than a preponderance of evidence standard. It is demonstrated where the defense shows that the failure undermined confidence in the conviction. Youngblood versus West Virginia. For example, in Buys versus Sheldon, the defendant was convicted for kidnap, assault, and murder. In addressing the cumulative impact of the undisclosed evidence, the United States Court of Appeals for the Sixth Circuit noted that had the evidence been disclosed to the defense, it would have allowed defense counsel, quote, to construct a plausible alternative narrative of the crime, unquote. Specifically, witnesses reported seeing a group that may have included the victim taunting Cordray close in time to the victim's murder. Police had determined that Cordray's palm print was similar to the print found at the scene, and one witness noted that Cordray had injuries to his knuckles after the murder. In vacating the defendant's conviction, the court held, quote, these facts had been disclosed, would have provided a compelling counter-narrative to the state's theory of the case and could have created a reasonable doubt as to the defendant's guilt in the minds of the jurors, unquote. The undisclosed evidence of Mr. Avery would have permitted the defense to construct a plausible alternative narrative of the crime. As stated previously, Mr. Romlow and Mr. Radon's testimony and the unedited flyover video would have established that the RAV4 was planted on the Avery property. The missing zipper voicemail and the undisclosed Heidel report would have changed the state's timeline of Ms. Hallback's activities and would have provided evidence establishing Mr. Hilgas as a Denny third-party suspect. The undisclosed Dacianda CD would have impeached Bobby, who was unimpeached as the state's primary witness, as well as established motive to name him as a Denny third-party suspect. 3. The circuit court erred as a matter of law in failing to address Mr. Avery's claim of ineffective assistance of trial counsel. A. Standard of review. The 6th and 14th Amendments of the United States Constitution guarantee Mr. Avery the right to effective assistance of counsel at critical stages of his prosecution. In order to prove that he received constitutionally inadequate assistance, Mr. Avery must show that 1, his counsel performed efficiently, and 2, counsel's deficient performance prejudiced him. We are now on page 81 of 150. Whether Mr. Avery received ineffective assistance is a mixed question of law and fact. A circuit court's, quote, findings of fact, including of circumstances of the case and the counsel's conduct and strategy, unquote, are upheld unless clearly erroneous. Whether counsel's performance satisfies the constitutional award for ineffective assistance of counsel is a question of law, which this court reviews de novo. B, failure to hire experts case law. In certain cases, the duty to investigate includes a duty to consult with and call expert witnesses to testify at trial. Quote, criminal cases will arise where the only reasonable and available defense strategy requires consultation with experts or introduction of expert evidence, whether pretrial, at trial, or both, unquote. Thus, there are times where the only adequate means of challenging expert testimony elicited by the state is to introduce contrary expert testimony in favor of the defense. Finding deficient performance for the failure to consult with and call a rebuttal expert where there are significant holes in the prosecution experts' conclusions that could only be adequately addressed through contrary expert testimony. Several cases in Wisconsin likewise hold that the failure to investigate and or call expert witnesses to discredit the state's case and or to support the defendant's theory constitute ineffective assistance. Likewise, in Thomas versus Clements, the defendant was convicted of intentionally strangling the victim to death. The defendant's defense was that he unintentionally caused the victim's death by putting too much pressure on her neck for too long during sex. To rebut this defense, the prosecution relied on testimony from the medical examiner who performed the victim's autopsy. The medical examiner testified that the hemorrhages in the victim's eyes and abrasions to her face indicated that the pressure applied to her neck occurred during an assault and was intentional. The Seventh Circuit held that trial counsel's failure to even consider contacting a pathologist to review or challenge the medical examiner's findings constituted ineffective assistance. Specifically, counsel knew that his client claimed that the death was unintentionally and that there were no signs of a struggle. The court concluded that to not even contact an expert, quote, was to accept the medical examiner's findings on intentional death without challenge and basically doom the defense theory of the case, unquote. C, failure to hire experts. Blood splatter. It is indisputable that the state's blood splatter expert's testimony regarding Mr. Avery's blood in the RAV4 was the most critical piece of forensic evidence used to obtain Mr. Avery's conviction. The state's blood spatter expert was unrebutted because trial defense counsel failed to present a blood spatter expert on Mr. Avery's behalf. On December 16, 2017, trial defense counsel, Mr. Strang, gave current post-conviction counsel an affidavit admitting that trial defense counsel was ineffective for failing to hire a blood spatter expert. Quote, I knew that an acquittal very likely would depend in part upon an explanation for Stephen Avery's blood being found in the Toyota RAV4, other than because he was in that car himself. To my recollection, I did not consider hiring a blood spatter expert who might have consulted, done independent testing, testified, or all three as to the bloodstains found in either of those two general areas of Ms. Hallback's car. I did not have a strategic reason for not considering or hiring such an expert or experts, unquote. Trial defense counsel committed themselves to one theory about the source of the planted blood by claiming that it came from the 1996 blood vial and was planted by law enforcement. However, trial defense counsel did nothing to substantiate the theory for 8 months prior to trial. And at the pretrial conference on December 20, 2006, they declined the state's offer to split the sample and perform simultaneous testing or to join the state in pursuing a single test. Mr. Avery told law enforcement that his finger, which had been cut open prior to October 31, 2005, re-bled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Mr. Avery consistently expressed his belief to his attorneys and the media that his blood found in Ms. Hallback's vehicle was planted and that it came from his trailer. In a recorded interview, he said he dripped blood from his finger into the bathroom sink. Mr. Avery's claim that he bled in his bathroom into the sink was corroborated by his blood found around his sink on his bathroom floor. He told law enforcement and trial defense counsel that as he was leaving his property on November 3, 2005, and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. Mr. Avery told trial defense counsel that he noticed that the blood had been removed from his sink when he entered his bathroom early in the morning on November 4, 2005. In current post-conviction counsel's motion filed on June 7, 2017, Mr. James, a blood spatter expert, opines in his affidavit that the blood drops and flakes from Mr. Avery found in the RAV4 were not from, quote, an actively bleeding middle right finger, unquote, as the state told the jury. Prosecutor Kratz erroneously claimed that the, quote, sheer volume, the sheer number of places, unquote, rule out that the blood in the RAV4 was planted. However, only 1 to 2 milliliters of Mr. Avery's blood was found in the RAV4. The experiments conducted by Mr. James with 1 to 2 milliliters demonstrates that the small amount of blood in the RAV4 was selectively dripped in certain places, but not others. Mr. James's experiments demonstrate that the blood was not from an actively bleeding finger because there would have been blood in many more places in the RAV4, including on the door handle, key, gear shift, interior hood release, hood latch, hood prop, or battery cable. Suspiciously, there are no bloody fingerprints of Mr. Avery in or on the RAV4, despite the fact that he could not have been wearing gloves when he allegedly deposited blood from the cut on his finger in the RAV4. Mr. James states in his affidavit that the contact stain by the ignition is consistent with being placed with an applicator. Mr. James opines that the blood flakes on the driver's side carpet rule out an actively bleeding finger because the blood would soak into the carpet and not form flakes on top of it. Similarly, EDTA blood would not form flakes on the top of carpet. Fresh blood dripped in a sink would coagulate in approximately 15 minutes and could form some flakes that could be scooped up and planted on top of the RAV4 carpet. If Mr. Avery had bled on the carpet, there would be a corresponding stain under the blood flakes. Additionally, the remaining fresh blood could be removed and planted. Man, I should have printed this out and highlighted stuff, because there's so many things I now want to go back over because these are big deals. Page 86 of 150. In Mr. James's affidavit, he refutes the state's expert, Mr. Stahlke's testimony regarding the origin of the blood spatter on the inside of the rear cargo door of the RAV4. Mr. James performed experiments which demonstrate that the blood spatter on the inside of the rear cargo door was caused by Ms. Halbach being struck with an object such as a hammer or a mallet while she was laying on her back on the ground behind the vehicle after the rear cargo door was open. Mr. James ruled out Mr. Stahlke's explanation that the blood was from Ms. Halbach's hair as she was flung into the rear cargo area. The blood-stained hair pattern on the panel in the cargo area was the result of the RAV4 being driven while Ms. Halbach laid in the cargo area bleeding from a head wound, which created multiple stains as the car moved. The blood-stained pattern evidence refutes Prosecutor Kratz's claim that the pattern was caused by the vehicle sitting stationary and Ms. Halbach being thrown in and pulled back out of the vehicle. In a similar case in Texas, the Court of Criminal Appeals held that the failure to challenge the state's testimony concerning blood spatter constituted ineffective assistance of trial defense counsel. In Abrams, the defendant claimed that she stabbed the victim, believing him to be an intruder. Specifically, the defendant claimed that she was taking a bath when she heard noises in the other room. The state elicited testimony contrary to the defendant's version of events to the effect that blood spatter in the defendant's bathtub indicated that the tub was not wet when the blood was deposited. The court held that defense counsel's failure to challenge the state's witness's testimony by, for example, presenting contradictory expert testimony qualified as ineffective assistance. Mr. James states in his affidavit that the most likely source of Mr. Avery's planted blood was from the blood in his sink and not blood from the 1996 blood vial as trial defense counsel claimed. Mr. James, because of his familiarity with EDTA blood vials, opines that the hole in the top of the 1996 blood vial tube was made at the time Mr. Avery's blood was put in the tube, and the blood around the stopper is a common occurrence and does not indicate that the tube was tampered with. Ballistics. Mr. Strang, in his affidavit on November 16, 2017, admitted that he was ineffective in not having ballistics and trace experts regarding FL, one of the bullets. Trial defense counsel failed to hire a ballistics expert to rebut the state's expert's testimony that Ms. Halbach's cause of death was the result of being shot into her skull with a .22 identified as FL. Current post-conviction counsel's ballistics expert, Lucian Haag, states in his affidavit that FL shows no evidence of having been shot into a skull. Mr. Haag explains that FL, identified as a .22 LR, was comprised of such soft metal that there would be detectable bone fragments embedded in the damaged bullet if it had been fired into Ms. Halbach's skull. Mr. Haag conducted experiments that demonstrate bone would have been embedded in a .22 LR bullet if it was shot into bone. Because no bone fragments were identified in FL during its WSCL examination, it is Mr. Haag's opinion that FL was not fired into Ms. Halbach's skull. Trial defense counsel missed the opportunity to cross-examine Mr. Newhouse about the absence of any bone particles in the report. DNA expert, quantities of DNA on hood latch. Trial defense counsel failed to present a DNA expert at Mr. Avery's trial. Current post-conviction counsel retained DNA expert Dr. Reich, a Harvard standard-educated molecular biologist. Dr. Reich has offered the following opinions which refute the state's DNA evidence. 1. According to Dr. Reich, it would take approximately 90 attempts at opening the RAV4 hood latch to deposit the amount of DNA recovered by the WSCL. The WSCL identified 1.9 nanograms, 30 microliters of a DNA solution at a concentration of 0.0616 nanograms microliter of DNA on the hood latch. Dr. Reich reached this conclusion by conducting a series of experiments on an identical hood latch. 2. Dr. Reich refutes the state's claim, quote, as having no scientific foundation, unquote, that the hood latch DNA was deposited by sweat from Mr. Avery's hands. DNA expert, groin swab. So gross. Trial defense counsel failed to investigate or raise the illegal seizure of 2 groin swabs from Mr. Avery on November 9, 2005, which could have been used to plant the DNA on the RAV4 hood latch. The facts surrounding the illegal seizure of the groin swabs are as follows. 1. Mr. Avery was arrested on a felon in possession of a gun charge on November 9, 2005, and he was taken to the Aurora Medical Center where nurse Faye Fritsch took 2 groin swabs from him in the presence of Special Agent Fassbender and Investigator Wiegert. After the groin swabs were taken, S.A. Fassbender and Investigator Wiegert conferred and determined that the search warrant did not call for that type of exam. Investigator Wiegert immediately stopped Nurse Frisch, and the exam was concluded. 3. According to Mr. Avery, Wiegert told Nurse Frisch to give him the groin swabs, and Mr. Avery observed Investigator Wiegert walk to the examination room receptacle as if to discard the groin swabs, but Mr. Avery did not observe Wiegert deposit the groin swabs into the receptacle. Mr. Avery's claim that the groin swabs were not discarded is corroborated by the following highly suspicious facts. 1. Nurse Frisch never charted on the forensic evidence sheet that she had taken the groin swabs, even though she charted that she took buccal swabs from Mr. Avery. That's the mouth. Nurse Frisch's charting indicates that the only law enforcement officer present was Sergeant William Tyson, but Special Agent Fassbender's report indicates that he met Investigator Wiegert at the examination and both of them were present in the room. It is beyond coincidence that it was Wiegert and Fassbender who interrogated Brendan, a vulnerable, intellectually impaired teenager who is most likely on the autism spectrum. They introduced the hood latch story in their March 1, 2006 interrogation. Agent Fassbender asked Brendan, quote, did he go and look at the engine? Did he raise the hood at all or anything like that to do something to that car, unquote. On May 16, 2006, when asked how he came up with the hood latch story, Brendan responded, quote, just guessing, unquote. It is a reasonable inference that Special Agent Fassbender and Investigator Wiegert were highly motivated to provide corroboration for the confession they created. Therefore, they ordered that the hood latch be swabbed for DNA evidence. On April 3, 2006, Fassbender and Wiegert specifically directed Deputy Hawkins and Sergeant Tyson to go into the storage shed where the RAV4 was located to swab the hood latch, battery cables, and interior and exterior door handles. At 19:37 hours, Sergeant Tyson swabbed the hood latch. Deputy Hawkins took photographs, including a photograph of the swab. After Sergeant Tyson swabbed the hood latch, he gave the swab to CCSD Deputy Hawkins for storage. The instructions Fassbender and Wiegert gave Hawkins and Tyson revealed their illegal plan because they failed to request swabbing of the interior the interior hood release lever and hood prop, which by necessity, Mr. Avery would have handled when opening the hood to disconnect the battery cable. They knew Mr. Avery was never in the RAV4, so no additional swabbing was requested. On April 4, 2006, Deputy Hawkins signed the hood latch swab over to Wiegert for transport to the WSCL in Madison. When Wiegert arrived at WSCL, he presented Wisconsin Department of Justice evidence transmittal form labeled blah blah. Deputy Hawkins' name was typed on the form as the submitting officer, which he was not. Then Wiegert hand-printed Hawkins' name on the form, again, deliberately misidentifying Hawkins as the submitting officer, which was a complete misrepresentation. Clearly, Wiegert switched the groin and hood latch swabs and fabricated the chain of custody documentation so that it would appear that Deputy Hawkins submitted the hood latch swab to WSCL. Trial defense counsel failed to investigate all of the surrounding circumstances that led to the groin swabs being illegally taken from Mr. Avery and the chain of custody on the submission of the alleged hood latch swab to the WSCL on April 4, 2006. According to Dr. Reich, and I'm going to have to leave in like 15 minutes. According to Dr. Reich, one way for forensic evidence to be planted is by the relabeling the forensic swabs. Dr. Reich offers the opinion that, quote, a rubbed groin swab taken from the defendant was relabeled and thus became evidence from a hood latch, unquote. Trial defense counsel never considered the possibility that the groin swab was substituted for the hood latch swab because they failed to investigate the chain of custody involving the hood latch swab and the illegal seizure of the groin swab. DNA expert Toyota Key. And where Dr. Reich opines that the DNA found on the Toyota subkey found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA on the exemplar subkey than what was discovered by the WSCL and used to convict Mr. Avery. Now we're page 93 of 150. Dr. Wright states, quote, an order of magnitude difference is a significant finding, unquote. Dr. Reich's experiments refute Ms. Culhane's explanation for the presence of Mr. Avery's DNA on the key and that Mr. Avery was a good shedder. Clearly, he was not. Forensic anthropology and Kerf Marks expert. Current post-conviction counsel's forensic anthropologist with Kerf Mark expertise, Dr. Symes, PhD, D-ABFA, offered the opinion in his affidavit that a microscopic examination of the suspected human pelvic bones performed in 2005 would have determined to a high percentage of accuracy whether the pelvic bones were human. Dr. Symes also opined that it was below the standard of practice for a competent forensic anthropologist to not perform microscopic and histological examinations of the possible human pelvic bone. Neither Dr. Eisenberg nor Dr. Fairgrieve performed a microscopic examination of the suspected pelvic bones. If the pelvic bones in the Manitowoc County gravel pit were shown to be human, the state's entire theory against Mr. Avery would have collapsed. The state claimed that Ms. Hallback never left the Avery property after she arrived, was murdered in Mr. Avery's garage, and her body was burned in his burn pit. If, in fact, Ms. Hallback was murdered in the Manitowoc County gravel pit and her body was burned there, the state could not have linked the crime exclusively to Mr. Avery. Audio enhancement expert. Current post-conviction counsel hired an audio enhancement expert to enhance the Sergeant Colborne dispatch call regarding the RAV4 license plate. The enhanced version, created by the expert, clearly reveals that a second person was with Sergeant Colborne and makes the statement, "It's hers." I will read that again. The enhanced version, created by the expert, clearly reveals that a second person was with Sergeant Colborne and makes the statement, "It's hers." The statement impeaches the testimony of Sergeant Colborne that he was not looking at the RAV4 when he made the dispatch call. Experiment to establish that RAV4 subkey was planted. Neither side subpoenaed Mr. Avery's bookcase to the trial. Trial defense counsel's failure to have the bookcase at trial to demonstrate the impossibility of the state's story about the discovery of the key was a fatal error. A simple experiment with the bookcase and Toyota key would have conclusively demonstrated that the key was planted next to the bookcase by Sergeant Colborne and Lieutenant Lenk. Conclusive proof that this one piece of evidence was planted would have collapsed the state's house of fabricated evidence. Current post-conviction counsel had experiments performed with an identical bookcase and an identical 1999 Toyota RAV4 key on a blue fabric lanyard that demonstrates that Sergeant Colborne and Lieutenant Lenk's testimony about the discovery of Ms. Hallback's key in Mr. Avery's bedroom is demonstrably false. Page 95 of 150, with me having to leave in approximately 9 minutes. Experiment to refute burning plastic smell of Ms. Hallback's electronic components. Current post-conviction counsel's investigator conducted a series of experiments refuting Mr. Fabian's trial testimony that on October 31, 2005, he was in the vicinity of Mr. Avery's burn barrel and smelled the distinct odor of burning plastic coming from Mr. Avery's burn barrel. The admissibility of experiments and recreations to support and illustrate an expert's opinions is well established in Wisconsin. The Wisconsin courts have held, quote, pretrial experiments may be admitted into evidence if their probative value is not substantially outweighed by prejudice, confusion, and waste of time. Experts are allowed to describe such experiments, state the results, and give their conclusions based therein, unquote. The experiments conducted by Mr. Avery's experts would all be admissible according to Wisconsin case law. Ineffective assistance of trial defense counsel in obtaining experts prejudiced Mr. Avery in his defense. The circuit court failed to address any of Mr. Avery's arguments on the ineffective assistance of trial defense counsel in failing to hire experts. Mr. Avery has demonstrated that trial defense counsel's deficient performance prejudiced his defense. Mr. Avery, quote, is not required under Strickland to show that counsel's deficient conduct more likely than not altered the outcome of the case, unquote. Rather, the question on review is whether there is a reasonable probability that a jury viewing the evidence untainted by counsel's errors would have had a reasonable doubt respecting guilt, unquote. Reasonable probability under this standard is defined as, quote, probability sufficient to determine confidence in the outcome, unquote. If this test is satisfied, relief is required. No supplemental abstract inquiry into the fairness of the proceedings is permissible. In addressing this issue, the court normally must consider the totality of the circumstances and thus must assess the cumulative effects of all errors and may not merely review the effect of each in isolation. The deficiency prong of the Strickland test is met when counsel's errors were the result of oversight rather than a reasoned defense strategy. It is not necessary to demonstrate total incompetence of counsel, and Mr. Avery makes no such claim here. Rather, a single serious error may justify reversal. Here, Mr. Avery's experts in blood splatter, ballistics, DNA, anthropology with kerf mark specialization, forensic pathology, police procedure, and audio enhancement have demonstrated that the state's experts made multiple serious errors in their unrefuted testimony to the jury. One error in and of itself justifies a reversal. Mr. Strang has provided current post-conviction counsel with affidavits admitting that it was oversight and not a reasoned defense strategy to fail to hire a blood splatter and ballistics expert. D, failure to investigate and impeach the state's primary witness, Bobby. In determining whether counsel performed efficiently, a defendant must show that counsel's representation, quote, fell below the objective standard of reasonably and effective assistance, unquote. Both failure to conduct a reasonable investigation and failure to call a witness to testify can constitute deficient performance. Incomplete investigations, which are the result of inattention or oversight, did not constitute a reasoned strategic judgment to satisfy the Constitution. Page 98 of 150, and I've got 2 minutes to go. Bobby was the state's primary witness against Mr. Avery. During his opening statement, Prosecutor Kratz explicitly informed the jury of the significance of Bobby's punitive observations of the date of Ms. Hallback's disappearance. Quote, "You are going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Hallback alive," unquote. At trial, Bobby testified that he observed Ms. Hallback's light green or teal-colored SUV pull up in his driveway at 2:30 p.m. on October 31, 2005. Bobby then observed Ms. Hallback exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Ms. Hallback walking towards the door of Mr. Avery's trailer. The following exchange occurred between Prosecutor Kratz and Bobby. Question: after seeing this woman walking toward your Uncle Stephen's trailer, did you ever see this woman again? Answer: no. Bobby then testified that he took a 3 or 4 minute shower and then left his trailer to go hunting. Bobby walked to a Chevy Blazer, which was parked between the trailer and garage. Bobby testified that as he walked to his vehicle, he observed Ms. Hallback's vehicle still parked in the driveway. Bobby further testified that he did not see Ms. Hallback or any signs of her. Bobby testified that when he returned to his trailer around 5-ish, Ms. Hallback's vehicle was gone. During his closing argument, Prosecutor Kratz once again emphasized the importance of Bobby's testimony and vouched for his credibility. Quote, "We talked more about the timeline and we heard from Bobby Dassey, again, in the same kind of position to be, his credibility to be weighed by you, but is an eyewitness. Again, an eyewitness without any bias. It is a," and then it says spelled intention, so it should be "an" when it said a individual that deserves to be given a lot of credit, because sometime between 2:30 and 2:45, he sees Teresa Hallback. He sees her taking photographs. He sees her finishing the photo shoot, and he sees her walking up towards Uncle Steve's trailer, unquote. Brian, Bobby's brother, told law enforcement that Bobby saw Ms. Hallback leave the Avery property on October 31, 2005, contrary to Bobby's trial testimony. Trial defense counsel was well aware that Brian had provided law enforcement with a statement that contradicted Bobby's trial testimony that Ms. Hallback never left the Avery property, as illustrated in their motion defendant's statement on third-party responsibility, which noted that Brian had told law enforcement that Bobby actually saw Ms. Hallback leave Avery property. On October 16, 2017, Brian provided current post-conviction counsel with an affidavit confirming that Bobby told him he saw Ms. Hallback leave the Avery property on October 31, 2005. That scared the hell out of me. That's my timer telling me I have to leave now. Alexa, stop. Oh my God, did that scare me? Trial defense counsel's investigator, Conrad Bates, has provided an affidavit that he was unaware of the police report of Brian's interview. So we are on page 100 of 150. So I am going to go fly to my doctor's appointment that I should only be... Alexa, stop. I told you stop, bitch. So I should be back, so my appointment's at 1. I should be back here hopefully by 1:30. And so then when 1:30 hits, then we will read from 100 to 150, so we will read the rest of it. And then I will also figure out what other stuff because there's some other things I have to do today. So I need to figure out if I go to the doctor, come home, read this final 50 for you, then that then that live is done. Then I go run my other things, and then I'll go in MAM Gossip, where we won't read through all of this. We'll just go over the big important things. So, all right, so I am ending this now. So remember, if I don't, that I am picking up on page 100. I'm going to leave my iPad at 100. All right, so I'm off to the doctor. Be back soon. Thanks for joining me.